She just told me she thinks she only has $100. When I was.
We're on the record in cause number 328370. The case is styled the state of Texas versus Breland Zanega Ferreira. Is that your full name? Belan Ferreira? Okay, how are you doing, Ms. Ferreira? That's good. Ms. Ferreira, your attorney, Mr. Wright Kimber, is appearing via Zoom. Mr. Kimler, how are you doing?
Pretty good, Your Honor. Thank you.
Okay, Mr. Kimler, do you have an announcement that you would like to make?
We're just going to set her on the trial docket, Your Honor.
Okay, just hold on a minute.
You can do, lights what?
Okay, the case is going to be reset to July 12th. Ms. Ferreira, you can get your reset in here. Once you get your reset, you'll be free to go and you have a blessed day. All right, just over here on the end, stand on the end in front of the court coordinator. And Mr. Kimberly, this will conclude your case and your court date will be sent to you. You have a
Yes,
blessed
sir.
day. All right, you excuse.
Thank you, Your Honor.
Okay, you're welcome. Now, Mr. Sullivan, your client is not here yet. I think it's Jolyn Burner.
Yes, sir. That's correct.
Yeah, he's not here yet. And now is he appearing in person?
Your Honor, I believe he is. I just texted my office to see if we had contacted him about this hearing this morning. I didn't know if he was going to come on Zoom or not.
Okay, well, we have a couple other cases on our dockets, so we'll wait for his arrival.
Okay, and I'll be glad to check on that, Your Honor. One of the things that happened was my criminal paralegal got COVID and just now got off of the quarantine.
Okay,
Today, so we've had a bit of a hiccup in getting things done in the criminal arena.
okay.
Thank you,
Okay,
Your Honor.
all right, you're welcome. We're on the record in 3 cases. First case is cause number 321508. Case is styled Jordan Ambers. Mr. Bailey, could you please go call Jordan Ambers? Second case is cause number 321510. Case is styled State of Texas versus Jordan Ambers. Third case is cause number 324508-1. And this case is styled the State of Texas versus Jordan Janae Ambers. Is your full name Jordan Janae Ambers?
Yes, sir.
How you doing, Miss Ambers?
Good, how you doing?
I'm doing all right, Miss Ambers. You're here represented by your attorney, Mr. John Macy. Mr. Macy, how are you doing?
I'm fine, Your Honor. Thank you for asking.
That's good. Mr. Macy, well, the state is here represented by its Assistant District Attorney, Mrs. Ashley Ramos,
Yes, sir.
and the probation office is here represented by Ms. Ashley Barlow. And
Your Honor,
yes,
if I may, we had the PSI done, and at the time the PSI was done, we were not in agreement on this case, but now that the PSI has been done and I've read it and Mr. Macy's read it, we came to an agreement in the case. Unless she has.
It was a paper my probation officer told me to bring for, the community service, stating that I was free.
Showing, okay, and what we might be working out is she still owes just a little bit more in her fees, and if she pays those fees, the MTRPs will be dismissed at that point. And then we've worked out an agreement in the new case. She just needs a little more time to get probation, what all they need for her to fully complete the probation.
okay, so so the case is gonna be reset for her to pay her fees.
Yes.
The fees to get the 2 MTRPs dismissed, Judge.
Now, let me ask you this here. Do we know how much she owe in fees?
$97.
She only owes $97 in
Yes,
fees?
sir.
Yes, sir.
Now, Miss Ambers, how long would it take for you to pay the
I can pay it
$97?
today after court.
You can pay it today?
Yes, sir.
Okay. And so what do y'all want to do?
Well, once she has that paid and I get something from the probation office, I can go ahead and sign the dismissal, but then we'll still need a reset to do the plea in the new case.
Okay, when do y'all want to
Just
the reset.
A month
standard?
or just whenever the court wants to reset her.
Well, normally, I mean, it's our standard is 30 days or 45 days or 60 days.
30 days is fine, Judge.
I think
Is
30
that
days
fine?
is fine.
Okay, so we're gonna reset it. Give us a reset that.
28.
Okay, it's gonna be reset to May 28th of 2021. And then on the 2 motion to revoke probations cases, they will, yeah, we'll set them all together, but she's gonna pay restitution. I mean, she's gonna pay her fees, and then to be dismissed, right? Pay fees to be dismissed. Okay. Okay, and I think she's supposed to be paying that today. Is that correct?
Yes, sir.
All right, you can, Mr. Macy, you can get your reset. Once you get your reset, you'll be free to go. And Ms. Ambers, your attorney is gonna get your case reset. Ms. Ambers, your attorney is gonna get your case reset. Once you get your case reset, you'll be free to go, and you have a blessed day. And you have a blessed day as well,
Thank you.
Mr. Macy.
Thank you, Mr. Ramos.
You can try. She has her papers on. She was still trying to.
3 cases. Troy Gerard.
Okay, we're on the record in cause numbers 321-854, cause number 322-796, and cause number 325-259. All 3 cases are styled the state of Texas versus Troy Joseph Gerard. Is that your full name?
Yes, sir.
How you doing, Mr. Gerard? You doing all right? Okay, Mr. Gerard, I have a note on this docket sheet that the last time you were here, your case was reset for you to hire an attorney. Is that correct? Have you hired that attorney?
A little bit more time.
Okay, okay, we're gonna reset this case for 30 days to give you an opportunity to hire your attorney, okay?
So, I do have a question. I was looking to hire Mrs. Holmes, and I didn't know if that was a contradiction.
Well, that'd be a conflict of interest, if you, that happens, yeah.
Just asking.
On the MTRPs, I'm sorry, Ms. Barlow just told me that he's paid his fees. He does have a new UCW, but as far as the MTRPs go, I'm going to sign a dismissal in those.
Okay, so those 2 cases will be dismissed?
I paid him off a couple days ago.
Which 2 of those?
The first 2 cases, I
The
guess.
first 2 cases, the 321 and the 322.
So I'm resetting 325.
Okay.
Yeah, just been having a hard time finding somebody that I can trust.
While they're doing that, would you just come up here and sign and report that?
Okay, this is,
You can just sign right
you
there.
sent it to dismissal.
Yes, Your Honor, I'm just logging in right now.
Whoever you want, if it's her, we'll just have to move it. I'll give you a copy of these. Unless when you hire
Oops.
someone, it'll probably change it.
You had to put it on there, yeah, right?
Is there any? You go back upstairs.
Your Honor, this is Charles Sullivan. My client's on here now under Jolin's Galaxy A21.
Okay, when we're ready for the case, we'll call it.
I signed those dismissals.
Thank you very much.
Oh, yeah. Okay, we're on the record in 3 cases. First case is cause number 321-854, Second case is cause number 322796. And the third case is cause number 325259. All three cases are styled the state of Texas versus Troy Joseph Gerard. Is that your full name?
Yes, sir.
Okay, Mr. Gerard, would you please raise your right hand? Mr. Gerard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Okay, Mr. Gerard, you may put your hand down. Mr. Gerard, prior to, I guess, you coming into court, I think a few months back, well, you were represented by Kevin Lane, is that correct?
Yes, sir.
On a couple of cases, is that correct?
Yes, sir.
And at that time, Mr. Gerard, we had mentioned on the record that it was a gentleman by the name of Nolly Gerard. And I asked you, did you know him? Is that correct?
Yes, sir.
And you stated that he was your uncle or cousin?
Yes, sir.
What was he?
Yeah, he's my uncle.
He's your uncle, right? And I also mentioned on the record that back before that case, that I was getting some gas at a station, a gas station at the corner of College and Major, and he drove up and asked me and told me that he had a relative that was in my court. Do you remember that?
I don't remember that part of the story, but I remember you asking me about, do I know who he is?
Right, but then you remember, well, just for the record, I told him I couldn't talk to him about the case. I didn't know who his relative was because he didn't give a name. And then I asked you where you related to him. Is that correct?
Yes, sir.
And so that's when I just kind of put two and two together, thinking that maybe he was referring to you. You remember that?
Yes, sir.
Okay. Now, earlier today, on this particular, now you have these three cases in court, and I noted on the record that you were to hire an attorney, right?
Yes, sir.
And then you mentioned that you wanted to ask me a question, and your question was that you wanted to hire Brittany Holmes, who is my daughter. Is that correct?
Well, yeah, but I didn't know how it goes. I have felonies too, so I was gonna see if it works for hiring for both, or if I could just hire.
Okay, but I
didn't know how it,
okay, and I inform you that it'd probably be a conflict of interest. Is that correct?
yes, sir.
Now, did you mention that in order to try to
No, sir.
get some type of favor or something from the court?
No, sir. I really have been doing my research on her, and I think she would be good to represent me for my felonies. I just didn't know. I didn't want to have to pay for a lawyer for this thing. But I just.
Okay, now the other thing is, your mother has a restaurant in Beaumont, is that correct?
Yes, sir.
And I've eaten at that restaurant, and I saw you over there one day, isn't that correct?
Yes, sir.
Okay, now, at any point during your cases that you've had in this court, did you ever approach me about anything regarding your case?
No, sir.
Have I ever approached you about anything in your case?
Never.
Okay, are you expecting any type of favorable treatment because of the fact that you mentioned that my daughter may be a possible, maybe your attorney that you would like to hire, or the fact that I've eaten at your mother's restaurant?
No, sir. I'm
Okay.
just looking for a better attorney because I did not resist arrest and I'm on probation for it right now.
Okay, now, Ms. Ramos,
Yes, Your Honor.
with that disclosure that this court has made, does the state have any objections to me proceeding on the case, or would the state like me to recuse myself from this case?
At this time, Your Honor, I don't think that recusal is necessary, and I did submit to the court on the two MTRP cases dismissals because he had paid all of his fees. And As for the third case, it'll still be pending in this court. Should he actually hire your daughter, I think at that point, we would see that there's a conflict, but if he doesn't hire her, which he has not yet, then I think there's no problem for it continuing in this court.
So, will the state be waiving any possible conflicts of interest
Yes,
in this
Your Honor.
case? Okay. Okay, so at this time, the court is going to, sign these dismissals. And Mr. Gerard, you can stand over there on the, X in front of the, well, she's not, in front of the court coordinator, and she'll get you, your, dismissals. Mr. Sullivan, your client got disconnected?
I guess so, Your Honor, but he was obviously on the cell phone.
Okay, we'll wait for him to try to connect back.
Okay, I just texted my office that he dropped off.
Okay. All right.
Thank you.
All right, you're welcome. We're on the record in cause number 298980. The case is styled the state of Texas versus Garrett Dave Chapman. Is that your full name?
Yes, sir.
Okay, how you doing, Mr. Chapman? That's good. Now, Mr. Chapman, we have a motion to revoke your probation. Now, Mr. Chapman, just raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may put your hand down. Now, Ms. Barlow, Mr. Chapman, Mr. Chapman, I see here you was in January, you was to hire an attorney?
Yes, sir.
And
Talked to a couple of times.
have you hired the attorney?
No, sir.
Why haven't you hired an attorney?
Just getting all the funds together.
Okay. You say you're getting all your funds together.
Yeah, to hire the attorney.
How much time do you need to get your funds together?
A couple of months, like.
Oh, well, it's not, we can't wait a couple of months. Are you working?
Yeah, I work at Lowe's. Pulled up.
Okay. I mean, we could reset you 30 days.
That's fine, but I mean, that's cool.
Okay, 30 days? Okay, let me do this. We're gonna reset you 45 days.
That's fine.
Gives us a little bit more time, okay?
I just got a raise yesterday, so I should be able to be.
Okay, well, we're gonna reset you 45 days to give you opportunity to hire your attorney, okay?
Yes, sir.
Stand over there on the X. You're gonna get your reset. Once you get your reset, you'll be free to go and you have a blessed day.
Yes, sir. Thank you. Yes, sir. No.
My name is Michelle and Terry.
We're on the record in cause number 327464, the state of Texas versus Ryan Leonard McQuillan. Is that your full name? Leonard?
Yeah, like Leonard Skinner.
Yes. How you doing, Mr. McQuillan?
No, not bad.
All right, that's good. Mr. McQuillan, you're represented in your case by attorney Charles McIntosh. He is appearing via Zoom. Mr. McIntosh, how are you doing?
Doing well, Judge. Thank you.
Mr. McIntosh, do you have an announcement for the court?
Yes, Judge. I have been talking with the state on this case. I have gotten an offer. We're trying to work something out. So I would ask for just one more reset. Excuse me. Just one more regular standard reset to see if we can work this out by the next court date.
Okay. Hold on for your court date. It's gonna be reset to May 28th of 2021. We will see.
Judge, can we move that either a week backwards or a week forward, please?
Okay, hold on a minute. It's gonna be reset to June 4th.
Okay, that works fine.
Okay,
And Mr. McQuillan, I'm in my office just across the street if you want to come see me.
okay. So, Mr. McQuillan, you're gonna get your reset here in court. Once you get your reset, you'll be free to go and you have a blessed day.
Yes, sir.
And Mr. McIntosh, your reset will be sent to you.
Thank you, Judge. I appreciate you.
And you're excused and you have a blessed day as well.
Thank you, Judge.
Okay, you're welcome. Mr. Padgett.
Yes, Your Honor.
Which one are you, Mr. Padgett?
Mr. Phelps, Your Honor, is present. Deputy Pepper just told me.
Okay, where is it?
I'll get you, Your Honor.
Make sure that you speak up so that the judge can.
We're on the record. We're on the record in cause number 328174. The case is styled the state of Texas versus Philip James Faust. Is that your full name?
Yes, sir.
How you doing, Mr. Faust?
How are you?
I'm doing all right. Thanks for asking. Mr. Faust, you're here represented by your attorney, Mr. Padgett. Mr. Padgett, you have an announcement for the court in
Yes,
Mr.
Your
Faust's
Honor, I
case?
do. Last week, Mr. Phelps pled guilty in drug impact court to a felony deferred adjudication probation. Ms. Ramos was kind enough to make an offer to me, which we are going to accept. We're going to try to work something out here that can run concurrent with the probation that he's on. If you would place us on a plea docket, Your Honor, there are some conditions we need to work out with my client. We'll be happy to dispose of the case on that date.
Okay, hold on a minute. Now, Mr. Fouts, I see here you have a DWI second. Were you given bond conditions? Were you informed that you have to have an interlock device on any vehicle that you own or operate?
No, sir.
Okay, well, could you reach me that blue? I'm gonna have to give you some, that's our standard bond conditions and county code at law number 2 and 3.
including drug work.
Okay, I'll go over with you.
We're gonna go over this
Now,
in detail afterwards, but listen.
We're back on the record in cause number 328174, case to style the state of Texas versus Philip James Fouts. We have Mr. Fouts in court, present with his attorney, Mr. James Paget. Mr. Fouts, what your attorney just handed you is a document that is titled Standard Bond Conditions and County Court at Law Number 2. Do you see that? It's the title. Standard Bond Conditions and County Court at Law Number 2?
Yes, sir.
Okay, now I will go over this bond conditions with you. Following the arrest and/or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, subsection A2 and subsection C2. Do you understand that condition? Condition number 3, it says that the defendant shall not communicate either directly or indirectly with an alleged victim of the offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition? Now, condition number 4, this is the one that I had mentioned to you earlier. A defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 4906. That section deals with DWI. Subsequent means a DWI second or more. So you have a DWI second, so this applies to you. So let me read it again. A defendant who has been arrested or accused of any subsequent offense listed under section 49.04 or 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that make impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after today. Okay? And it's entered this day, which is 16th day of April 2021, and it's signed Judge Terrence Holmes. Now, do you understand these conditions? All right. Now, we ask that you just please adhere to these conditions. And I thank Mr. Paget, have you already received your reset on
No,
this
Your
case?
Honor.
Okay, we'll get you your reset. You can stand over here on the X and we'll have the court coordinator to give you your reset. Once you get your reset, Mr. Fouts, you'll be free to go. You have a blessed day.
Thank you. Mr.
And Mr. Paget, I think you may have another case.
Yes, Your Honor.
All right.
I just looked outside and I'll bring this up to you.
Oh, I'm not ready on that one.
Okay.
These are.
Go on the record. I have one on this here. Okay, let me repeat that. Okay, we're on the record in cause number 324-255, State of Texas versus 2Win. Mr. Wynn, would you come forward? Have Mr. Wynn to come forward. And now Mr. Wynn is Vietnamese. He has an interpreter by the name of Sonny Wynn. Is that correct?
Yes, sir.
Mr. Sonny Wynn, would you please raise your right hand to be sworn in? Would you swear in? Okay.
Do you solemnly swear that you will interpret the, I don't have an interpreter thing in front of me today.
Okay.
If you will interpret from Vietnamese to English
In English,
and
yeah.
English to Vietnamese to the best of your ability, so help you God.
Yes, I do.
Okay, you may put your hand down. Now, as I said, now Mr. Burbank, he is appearing by phone. He is the attorney for Mr. 2Win. We have also Mr. Larry Dowden, who's in court. Mr. Dowden has filed a motion to substitute in this case for Mr. Wynn. And Mr. Burbank, are you opposed to that motion?
No.
Okay, Mr. Burbank is not opposed, so Mr. Dowden, that motion will be signed. This will. Okay, thank you, Mr. Burbank. Y'all have a blessed day. Okay. Okay. Now, Mr. Dowden?
I know we're probably premature to judge it, just Mr. Wynn's really anxious. He's got like 17 days that he served.
Okay,
in
well, so
Galveston.
y'all just trying
We're
to,
working an
okay,
agreement out.
just talk to the prosecutor and then y'all come back.
Well, actually, we have one, right? From
Okay.
this afternoon.
Yes, we just have to fill it out on the tablet.
So we'll do it today.
Okay, that's
I
fine.
thought we were gonna surrender ourselves.
That's fine.
If it's,
You taking care of it today, right?
well, Judge, or we can, if it's an inconvenience at all, he can surrender himself. We were kind of prepared to surrender ourselves and maybe Thursday, if he's on the run, Mr. Wynn and I would go out to the jail and see you by Zoom if it's more convenient.
We only got
I just don't
two
want to hold
cases.
you
We
over
only
on
have like
Friday.
you and somebody else. We don't have that
Okay.
many cases left.
Okay, I mean, I just don't want to hold you over.
Yeah,
If y'all had something else.
yeah,
going
no,
on.
you can have a seat. We're gonna, Mr. Paget next.
I'll have to go up
who oh, that's right, this was Mr. Okay, we on the record. Mr. Shearer, are you ready?
Yes, Your Honor.
Okay. We're on the record in cause number 324708. The case is styled the state of Texas versus Tiffany Shannon Roan. And the state is present with Assistant District Attorney, Attorney Ray Shearer. We also have from the probation office, Miss Annette Jones, probation officer in this case. And this case is on the docket because the court received a letter or a memo from Mrs. Annette Jones concerning this particular case. And I think from the memo, she had discussed the matter with previously with Mr. Ray Shearer. Mr. Shearer, would you like to go forward?
Well, I would, but I'm not quite sure what I'm going forward on. And at this point, I'm also raising concerns about having a hearing regarding Ms. Roan when neither the defendant nor her attorney is here.
Okay.
I understand that there's been some unusual activity with this case, and if the court would like to be brought up to speed as to exactly what happened.
Well, what we need to do,
Happy to
no.
meet in chambers and.
I think what we did was we had Miss Annette Jones had sent the memo, and I thought it would be appropriate. And I think when Miss Annette Jones was to see if she was going to try to contact Miss Roan, is that correct?
Yes, sir. We had no information, no way to contact her because she never reported to our office.
Okay. So, but no, Mr. Shearer has brought up the point that we need to have at least, well, we need to have Miss Roan. And I know Mr. LeBlanc, apparently he's not, he probably wasn't given notice either. So with that in mind, we won't be able to have a hearing on this case today.
Your Honor, as I stated, and the state's position is we understand that there's been some unusual occurrences with this.
Right.
But we don't feel like it's anything that was the fault of the defendant. And we feel like that although the court may want to do an inquiry as into the circumstances around this, the state's position is that the defendant should be discharged for credit time.
Okay, well, we need to, do you have any case law on that?
Well,
Support your position?
The Sheriff's Department in their notes has said that she's
Yeah.
received credit time.
No, well, what I'm saying is, do you have any case law to support that the court has the authority to do what you're asking for?
I think it would be best termed as in the interest of justice.
Well,
Because
but,
I
like
mean,
I s-
a wrong has been committed here.
Well,
And to continue this is to continue the wrong.
yeah, but I know, but we are a court of laws. And so either the court has to act in relation to, we apply the facts to the rule of law. And so that's why the court asks, if there's a statute or there's case law out there, something to give the court some guidance in making the decision that need to be made in the interest of justice.
I understand.
Okay, so at this point, but at the same time, we still need to give, we're gonna see if the probation officer do its best to try to contact as well, and then if you're able to make some contact, then we can contact her attorney to give him notice as well. Okay? So at this time, we won't be able to do anything on this case today. And so until we hear back from the probation officer regarding the contact, then we may be able to not submit, but we may be able to at least reschedule the hearing
Yes, sir.
on a date certain. All right. All right, this will conclude this case. Okay, we don't, well. Ashley, are you available? Ashley, are you available? No, she's not.
Yes, Your Honor, I was trying to go grab the tablet.
Oh, okay. Okay, we'll give you some time.
Okay, thank you, Your Honor.
Mr. Sullivan, were you trying to show me something on the screen?
No, Your Honor, I don't know what happened to my client. He was obviously on the cell phone, and I don't know if he doesn't have enough bandwidth wherever he's at to get on or what the deal is. But the status of this case is it's been reset a number of times by the court. This is my first appearance before the court, and I don't have the discovery. We requested the discovery in the case.
Just hold on a minute. Okay, well, we have a prosecutor back, and what we're gonna do, your client did make an appearance. I understand that he may have some technical difficulties. Let's see. We on the record in cause number 326-464, State of Texas versus Jolyn Glenn Berner. And just for the record, Mr. Berner did appear via Zoom earlier. However, the court was in session on some other matters, and during the session, his Zoom connection dropped. And Mr. Sullivan, Mr. Charles Sullivan is his attorney, he has appeared on Zoom. And Mr. Sullivan, you have made several attempts to try to get him back on Zoom, is that correct?
Yes, sir. My office is trying to contact him, but they're unable to do so.
Okay.
It looked like he was at work. It looked like he was at work somewhere to me, and who knows if he has a good cell service out there. And obviously, there's a pretty good deal of bandwidth that's needed to operate Zoom.
Okay. Now, Mr. Sullivan, what is your announcement in Mr. Berner's case?
Your Honor, I'd like a reset and I'd like to have a chance to confer with the district attorney's office.
So you need to have, I guess,
And I mean, if we could go to a breakout room now and talk a little bit about it. It's a possession of marijuana case, and I'm assuming that that I'm entitled to get discovery, but I haven't gotten any discovery yet.
Yes, I checked into that just now. We previously had a different prosecutor on this case, and so I was looking at our discovery portal. Mr. Sullivan, I don't know that you've ever been set up on our discovery portal before.
No, I have not.
Okay, just give our office a call and we can get you the link to get set up on that, and then I can get you the discovery granted.
Okay, can I get one of the folks that works for me to do that?
Sure, they can just give our office a call.
Okay, all right. Thank you very much. And Your Honor, I would just ask that it be reset for 30 days or something so that we have a chance to look at the discovery and discuss it with Ms. Ramos.
okay, it's gonna be reset to May 28th.
Your Honor, I quite likely will still be in a jury trial that day.
Okay,
Uh,
what about June 14th?
June 14th would be great.
Hold on, well, she said June 11th.
June 11th is fine, Your Honor.
Okay, this is gonna be reset to June 11th. Your reset will be sent to you. And this will conclude your case. You're excused, and Mr. Sullivan, thanks for being patient with us, and you have a blessed day.
Thank you for your patience as well, Your Honor.
You're welcome. We got, okay. Ms. Ramos,
Yes, Your Honor.
let's see here, we have James Blackshear.
Yes, Your Honor. And I received a call about right as I came back up in my office from my witness in the case, and she was running a few minutes late.
Let me
A moment to talk to her, and we may have a resolution in this case.
Okay, that's fine. Now, let me tell, this is what I had looked at the statute, which is, hold on a minute. Where is it? Trying to figure out where it is, huh? Oh, here it is. Yeah, I had looked at the statute. Oh, let me do this here. Mr. Padgett, would you come on up?
Yes, Your Honor.
And Mr. Blackshear, would you come on up? Okay, we're on the record in cause number 324-906. Case of style of state of Texas versus James Alfred Blackshear III. Is that your full name?
Yes, sir.
Okay, how you doing, Mr. Blackshear? That's good. Now, Mr. Blackshear, you're here represented by your attorney, Mr. James Padgett. Mr. Padgett, how you doing?
Doing well, Your Honor.
That's good. The state is represented by Mrs. Ashley Ramos, assistant district attorney in this case. Now, Ms. Ramos and Mr. Padgett, I looked at this. Well, first of all, this case was scheduled for a restitution hearing. And I looked at the statute that deals with restitution in the Code of Criminal Procedure, Article 42.037. And basically, when we talk in restitution, that's a punishment issue. And so obviously you have to have a plea in before you get the punishment. You know, you have the two phases. You have, because we have I guess what you could say in legal terms is a bifurcated system. So the second phase of our system after trial is punishment. After guilty and innocence is punishment. And so restitution is a punishment issue. And so to make a long story short, there has to be, I guess, a a plea in first, and then when the court gets the punishment, then we can have a restitution here if needed. Okay? And so before we can even go forward on a restitution here, we have to get through the guilt and innocent phase, which is either him, having a jury trial or whatever, or him entering a plea before the court. And then when we get to that position in terms of determining restitution, that's the punishment. We'll be in the punishment phase. Okay? So at this time, we don't have a plea done, so we can't just go to it's kind of like it's putting the cart before the horse. And so we can't do the punishment phase before the guilt and innocent phase, is what I'm saying. Okay? So at this time, once we get to the punishment phase, the court will be in a position to have a restitution hearing if one is needed. And I think from what Ms. Ramos has said, there may be a resolution.
We'll know when the complainant will.
Right, and so if there's a resolution, we won't necessarily need a restitution hearing.
Yes, Your Honor.
Is that correct, Ms. Ramos?
That's correct, Your Honor, and I apologize for the confusion on that. I didn't think about that is a punishment issue.
Okay, no problem. Okay, so let me do this here, Mr. Paget.
Yes, Your Honor.
Are you gonna? Well, I'll do this here. I'll just let y'all continue to negotiate, and then if a reset or something is needed, just get with the court coordinator.
That's exactly what we'll do, Your Honor.
Okay.
I feel pretty confident in Ms. Ramos when she gives me her word normally.
Okay.
I don't have any problem with it. So-
All right. So we'll let y'all negotiate, and then you get with the court coordinator with regards to a reset.
While we're on the
if needed.
record, I'll just go ahead and point out, I mean, our issue is restitution, so if we can come to a resolution, what we'll do is we'll want this case put on the plea docket
Right.
in order to give my client time to get the proper restitution.
That's fine.
Okay,
That's fine.
thank you, Your Honor.
All right. You welcome.
Okay.
All
We
right.
can just have a seat and relax outside. It's